What's going on, good people? It is the man in black, Mr. Wolf himself. Let's get into it. So, if you're like me, you've often wondered when, where, how, who gave who permission to regulate commerce. What is commerce? Now, we already did a video on what commerce is. It's for profit. Anything outside of your own personal needs, personal use, private use is not commerce. They do not regulate that unless you do some type of controversy, then they get involved in your matter. Or should I say, your matter registers itself into the public. It's an activity. They regulate activity. So we also know that on the public side, underneath their regulations and in their jurisdiction, they too also have a type of private side or personal side, not to be confused with the United States of America and your God given inalienable rights, privacy, liberties, and freedoms. They form their own little niche. So don't get it confused. There's the real private, and then there's the regulated, sanctioned private that exists on the public side. So without further ado, let's jump into this. And I found a little something that finally proves what I've been saying. And I'm not going to say that the law library is trying to obfuscate things. Seems like they're trying to do the right things for the most part. So I was able to find something that proves my point, one of my points. And when we get there, oh, best believe I'll let you know. Once again, guys, hit that bell, like, subscribe. Welcome to the tribe. The truth will not be denied. Your favorite national born natural, James C. And we're here for all things truth, rights, liberties, and freedoms. God bless America and the American people.
The Commerce Clause is Article 1, Section 8, Clause 3 of the U.S. Constitution, which gives Congress the power to regulate commerce with foreign nations, among states, and with the Indian tribes. Congress has often used the Commerce Clause to justify exercising legislative power over the activities of states and their citizens, leading to significant and ongoing controversy regarding the balance of power between the federal government and the states. The Commerce Clause has historically been viewed as both a grant of congressional authority and as a restriction on the regulatory authority of the states.
So we learned a couple of things. We learned that the Constitution gives the government, Congress, the power to regulate commerce with foreign nations, the states, and Indian tribes. And then the activities of states and their citizens. We're talking about U.S. citizens here in this particular point. Let's keep going though. Okay. You could also look at this to say that this also means any. Now we know they can't regulate nationals. So here, if they could regulate something, then it's got to be the activities of the state's U.S. citizens, not the nationals, because there's no law. We created the law. We created the government. We created Congress. You can't regulate something that is your boss, your owner. We finance. We don't boss because we don't come together. We gave it a life of its own, essentially. We're like grandparents who are sleepy in the back room, and the kids are now adults ish and they're running amok.
States. The Constitution does not explicitly define the word commerce, leading to wide debate as to what power Section 8, Clause 3 grants Congress. Some argue that it refers simply to trade or exchange, while others claim that the framers of the Constitution intended to describe more broadly commercial and social intercourse between citizens of different states. Courts have generally taken a broad interpretation of the Commerce Clause for much of United States history. In 1824's Gibbons v. Ogden, the Supreme Court held that intrastate activity could be regulated under the Commerce Clause, provided that the activity is part of a larger interstate commercial scheme. In 1905's Swift and Company v. United States, the Supreme Court held that Congress had the authority to regulate local commerce, as long as that activity could become part of a continuous current of commerce that involved the interstate movement of goods and services. For a brief period between 1905 and 1937, the Supreme Court narrowed their interpretation of the Commerce Clause in what has now become known as the Lochner era. Courts during this era experimented with the idea that the Commerce Clause does not empower Congress to pass laws which impede an individual's right to enter a business contract. However, beginning with NLRB v. Jones and Laughlin Steel Corp. in 1937, the court began to recognize broader grounds upon which the Commerce Clause could be used to regulate state activity. Most importantly, the Supreme Court held that activity was commerce if it had a substantial economic effect on interstate commerce or if the cumulative effect of one act could have an effect on such commerce. Decisions such as NLRB v. Jones, United States v. Starby, and Wickard v. Filburn demonstrated the court's newfound willingness to give an unequivocally broad interpretation of the Commerce Clause. From the NLRB decision in 1937 until 1995, the Supreme Court did not invalidate a single law on the basis of overstepping the Commerce Clause's grant of power. In United States v. Lopez, 1995, the Supreme Court attempted to curtail Congress's broad legislative mandate under the Commerce Clause by returning to a more conservative interpretation. In Lopez, the defendant was charged with carrying a handgun to school in violation of the Federal Gun-Free School Zones Act of 1990, 18 U.S.C. Section 922Q. The defendant argued that the federal government had no authority to regulate firearms in local schools, while the government claimed that this fell under the Commerce Clause on grounds that possession of a firearm in a school zone would lead to violent crime, thereby affecting general economic conditions. The Supreme Court rejected the government's argument, holding that Congress only has the power to regulate the channels of commerce, the instrumentalities of commerce, and action that substantially affects interstate commerce. The court declined to further expand the Commerce Clause, writing that to do so would require us to conclude that the Constitution's enumeration of powers does not presuppose something not enumerated, and that there never will be a distinction between what is truly national and what is truly local. This we are unwilling to do. Nonetheless, Lopez did not indicate a full return to the Lochner-era conception of the Commerce Clause. For example, in Gonzalez v. Reich, the court returned to its more liberal construction of the Commerce Clause in relation to intrastate production when it upheld federal regulation of intrastate marijuana production. In 2012, the Supreme Court again addressed the Commerce Clause in NFIB v. Sebelius. In Sebelius, the court addressed the individual mandate in the Affordable Care Act, ACA, which required uninsured individuals to secure health insurance or pay a monetary penalty in an attempt to stabilize the health insurance market. Focusing on Lopez's requirement that Congress regulate only commercial activity, the court held that the individual mandate could not be enacted under the Commerce Clause. The court stated that requiring the purchase of health insurance under the ACA was not the regulation of commercial activity so much as inactivity and was, accordingly, impermissible under the Commerce Clause. Nonetheless, the individual mandate was allowed to stand because it could reasonably be characterized as a tax.
So what they're telling you here is a couple different things. They can only regulate certain things, and if you're underneath those things, taxpayer, doing commerce, or whatever else, they can force you to do these things. But there's a difference between an individual as a private citizen, and within that same person, that person operating as a U.S. citizen. They can tell the U.S. citizen to do these things if the U.S. citizen is doing commerce or elects to be treated as a U.S. citizen and they're doing commerce. Because the U.S. citizen is a member of theirs. So they're really only talking to their members. Nowhere in here did you see anything about the national or the state citizen, non resident. They said individual, but an individual usually means the living person, but can also mean a regular person. And if they don't define how what the individual is here specifically, then it's open to interpretation. It's subject to interpretation. A lot of people out there, these other gurus on their channels, they don't understand the subtle nuances of the law. They're not the legal department. They read basic shit because they got a basic mind and they give you a basic ass answer. That's half ass. It's not that it's completely wrong. They just don't know the deeper meanings. They never spent time in courtrooms other than being handed a fine and a sentence. Most of them. They ain't never really been there fighting for their life. They ain't really learned the law. They ain't never spent no time with lawyers, attorneys, like I have. And then you start to learn that, hey, there's a hole here. I can challenge the word individual. I can challenge the word regulate. I can challenge, what do you define as commercial activity? Every single word, phrase, and how it looks can be challenged. They don't like it because they go, oh, you're just trying to drag the cord on. You're just trying to slow the cord up. You watch too many YouTube videos. You're right is that they must 100% perfect against you every single thing that they're saying and provide evidence, discovery. They must provide it. If you don't ask for these things, the court just kind of walks over it and it's ignored. Let's keep going because they're about to get to the good part.
Commerce Clause. The Commerce Clause, Congress, the con however, nonetheless, Lopez did
Okay, whatever. It's going to act funny. We're at the last section anyway, so I'll just read it. While most discussion surrounding the Commerce Clause revolves around the federal government, it also indirectly affects state governments through what is known as Dormant Commerce Clause. The Dormant Commerce Clause is the prohibition implicit in the Commerce Clause against states passing legislation that discriminates against or expressly burdens interstate commerce. Of particular importance is the prevention of protectionist state policies that favors state citizens. Booyah! I told you the state citizen was a real thing. And I told you the state citizen passport was a real thing. You can also see here it says last reviewed in April of 2026 by Wex Definition Team. So these are probably the people who watch my videos and make corrections. And they're probably part of the legal department. I would assume so, or they're working with. But so they just seen this as of April. But they wouldn't have known this is something that I needed to see and to show to you guys. Proof is in the pudding. Here is the fact that state citizen is a real thing. This is Cornell Law, Legal Institute. Now, does that mean that this term is used today a whole lot? No. They're talking, all this is talking about from back in the day. But this goes to show you that back in the day, they referred to nationals that we call today national of the United States, non-citizen U.S. national as state citizens. There it is, guys. This is the proof. This is the proof. Now, once again, a lot of you guys, even though I made the video, have not done a FOIA request on your passport from back in 1996. Oh, hold on. They got my screen all choppy. Must be hacking into my feed. So I'll wait. I'll just wait until it clears up. All right, there we go. So once again, here's the proof, guys. State citizens. This was the official term. So what they're talking about here is back in the day. The term is still here. It's just not used a whole lot. But this is the proof of the state citizen passport. Because guess what? Back in these days, guess who they gave the passport to? The state citizens. It did not start off with being available for U.S. citizens. So state citizens. And then they added the ability for somebody to regard themselves or to represent themselves as the U.S. citizens. But here it is. Here's the old terminology. Okay, so to finish up, or businesses at the expense of non-citizens conducting business within the state. And we all know what within the state means. Not merely in the physical area, but in the physical area and registered, or their name or entity found within their database, in their registration, documents, file, computer. That why do you think the cop always goes back to his computer to run your information? He needs to see if you're a member underneath his jurisdiction. It's not just because you're physically in the area. He has to see if you're registered to do school, registered to do business, registered as a member of theirs, your property, you're a trustee. The Supreme Court struck down a Massachusetts state tax on milk products because the tax impeded interstate commercial activity by discriminating against non-Massachusetts citizens. So non-Massachusetts citizens, state citizens, Massachusetts, and businesses. Okay. Some of the information you can read if you want. I've already been through almost all of this within my research. Okay. Tax is a charge of money or property that is imposed by a government, lowercase g, upon individuals or entities that are within the government's authority to collect. This is why U.S. citizens, they have authority to directly tax. They don't with the national, unless the national converts himself to a police officer or a postal worker or something like that. Or the event for a national is something that's taxable, like the lottery. But the national in general, just working, not a government or state government type job, is not taxable. But they can still buy things that are taxed. though technically they should be all tax exempt when buying things. But one could argue that a store, though they are supposed to absorb the tax and pay it themselves, they pass that on to the people who buy it. One could argue when you're buying food, you're looked at as a US citizen, not a national, because they're offering it as a business to anybody, but generally you have not proven that you're a national. And then if you want to prove that, then you've got to go to the state and get an exemption because those products put together, packaged, they're all done commercially. And that means it's commerce. And that is for 14th Amendment US citizens. It's actually quite easy when you think about it. This term, however, generally does not include charges imposed in exchange for the provisions of specific goods and services. Entities refers to a person. So see, look right here. Entities are persons. How, are you an entity? This person must appear. So what are they saying? This entity must appear. Or organization possessing separate and distinct legal rights, such as an individual, partnership, and they don't hyperlink and define individual. A legal entity corresponding to the notion of a legal person. So you've got a legal entity and a legal person. The legal entity holds rights, and each entity has a legal status. So that's why they want your legal name. Lowercase s, state. A state, lowercase s, is a political division of a body of people that occupies a territory defined by frontiers. The state is sovereign in its territory, also referred to as jurisdiction, and has the authority to enforce a system of rules over the people living inside of it. Not the physical jurisdiction, but the registration, which then allows them to have their own constitution, statutes, regulations, and common law. If you notice down here, it says these are considered sovereign states: Alabama, Alaska, Arizona, Arkansas, California. Doesn't say state of Alabama, it doesn't say state of Alaska. They're separate things. And what they did is they created a different type of government. This is Alabama state. They created state of Alabama. The former has the real power. Alabamians, the Republic, Alabama state. But that's an organization or association of people, loose, sparse, all over the place. State of Alabama has a capital and this and the that and the blah, 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 blah. Those are different things sharing the land, but the state of Alabama had to get permission from Alabama to do business in this area. And then now the state of Alabama regulates 14th Amendment citizens and people, those registered persons to them in a political sense. So these are the 50 sovereign states. A legal person is a human or non-human legal entity. I would argue that a legal person is not a human. But then again, we don't know here what their definition of human is. Hue meaning spectrum, man. So a spectrum of a man. I wouldn't even sit here and call myself a human. So they define income tax by the power to collect income tax as found in the Constitution. That is not a proper definition of a word or a term. Income tax is, if I were to define it, would be profit or gain derived from an extracurricular activity that was not directly earned in the form of personal compensation or private compensation by someone who is taxable, which would be generally a 14th Amendment U.S. citizen, legal person, entity of a government, because that's what it is. And here they talk about the power to collect it, but they don't talk about the actual intrinsic definition of it. One could fight that on moot for vagueness. All right, guys, that's it. Hopefully, you guys enjoyed the segment. Once again, finally, of all things, all these years I've been doing this, not one article provable from a legitimate legal source or school could we find the term state citizen used. And now we have. I rest my case.